Start. The learned counsel for the petitioner has impugned the order on the grounds that the parents did not prove that the applicant refused and neglected to maintain them. Full stop. Not a single incident indicating refusal and neglect has been pleaded and proved. Full stop. The bar words were insufficient to prove refusal and neglect to maintain. Full stop. The court was not clear about appreciating the oral evidence. Full stop. The petitioner's oral evidence was received, but a similar rule was not applied to the son/petitioner. Full stop. He never refused and neglected to maintain them. Full stop. The petitioner/son has purchased the home where his parents, brother and sisters reside. Full stop. It was agreed among the siblings that they would pay him some money as rent for using his house, and from that money, he would maintain his parents. Full stop. However, they stopped paying the money as agreed, therefore, he issued a notice to them. Full stop. This fact has been ignored and brushed aside by the courts. Full stop. The court completely avoided discussing the evidence laid by the applicant and pick and choose the evidence favoring parents. Full stop. These are the apparent errors on the face of the record. Full stop. However, the petitioner being a son, has to perform his obligations. Full stop. He is ready to pay rupees 3,000 per month to them. Full stop. He also has family responsibilities. Full stop. His wife is suffering from cancer. Full stop. He has to repay the loan borrowed for the marriage of his daughter. Full stop. His son was a college going. Full stop. His expenses are more than his income. Full stop. The courts did not consider these aspects while determining the quantum. Full stop. He prayed to modify the quantum to rupees 3,000 per month from rupees 5,000 per month. Full stop. Per contra, the learned counsel for the parent has argued that the impugned judgment and order is free from infirmity, error, and illegality. Full stop. Para. The court has correctly appreciated the evidence. Full stop. Now his son got a job and making handsome money. Full stop. The parents had no reason to make false allegations against the son for maintenance, and there were circumstances sufficient to establish the case. Full stop. The son/petitioner has refused and neglected to maintain them without sufficient reason. Full stop. The learned counsel for the son/respondent has correctly pointed out that the burden was on the parents to prove refusal and neglect. Full stop. Admittedly, the parent did not depose any specific incident. Full stop. As far as the evidence of refusal and neglect to maintain is concerned, it may be by words or conduct. Full stop. It may be expressed or implied. Full stop. Neglect or refusal may mean something more than mere failure or omission. Full stop. The mother explicitly deposed that they require medication, but the present petitioner refused to provide. Full stop. She has also deposed that they purchased the house where they were residing under one roof in the name of the applicant. Full stop. Specific evidence has been laid making allegations against the applicant that he refused and neglected to maintain them. Full stop. His defense that he had to maintain his parents from the rent from his siblings and they stopped him paying money shows his conduct. Full stop. He was trying to shift his burden on his siblings. Full stop. It appears, the real dispute is about the house, which stands in the name of the applicant. Full stop. An agreement with the siblings for rent has no direct connection with the issue before the court. Full stop. His conduct is sufficient to believe that he impliedly refused and neglected to maintain the parents. Full stop. Reading the evidence as a whole, the court believed that the parents had proved that the applicant refused and neglected to maintain them. Full stop. Whether the offer was bona fide or genuine was to be tested by the court, as provided under subsection 4 of 125 of the CRPC.